Welcome to this month's edition of Stephen's Squibs, brought to you by the Center for Child Counseling. It's time to gather around the proverbial fire and discuss Florida family law cases and more. Please welcome your host, Eddie Stevens.
Hello and welcome to the special February 15th edition of Stephen's Squibs Family Law Monthly CLE. And by now, everybody should have received their 2021 copy of Stephen's Squibs. Over 500 pages of really delicious squibs. And if you haven't received it yet, something has gone wrong. So drop us a line and we will send you a copy. Otherwise, we sent out a mass email to get your addresses, and everyone that responded should have received one by now. If not, let us know. We have a great show for you today. We're going to have a board cert tip with the fourth person who passed board cert, Christie Guerrero. I hear that number has increased to 6 now. And we have a very special legend interview. CARYN will be interviewing the legendary Joel Weissman. So get ready for that. But to start the show off, I have, of course, my cohorts, CARYN Stevens and GINA SZAPUCKI. Hey guys, how you doing today?
Hey, good afternoon. Happy February.
Yes, happy February to everybody.
Can you believe it? And I hope everybody had a great Valentine's Day. I know I did. In front of you are the materials where in December, the appellate courts put out 20 family law cases. They're all numbered in front of you. The first one doesn't require much discussion. The Goodman case, it's an appellate case where the court did not follow the mandate specifically, so it was sent back. If a appeal comes back with mandate instructions, it's really important for the court just to follow those instructions. It's a jurisdictional issue. The second case comes under enforcement. And this was a appeal of a contempt order out of the first DCA, Ringing Bird v. Ringing Bird. And it dealt with a contempt order that modified time sharing, but because the motion itself did not allege a substantial change of circumstances, the case was not at issue and the court lacked jurisdiction to make any of those decisions. The court would have also had to have found that the modification is in the child's best interest. We're going to now flip down to equitable distribution, one of our favorite subjects. And the first case is the Rennert case. And this was kind of an interesting case where the appellate court cited the Fingal case, which talks about mingling dollar bills and losing a non-marital status to marital status, but this one dealt with real property. And the circuit court thought that because the mortgage was paid down through income earned during the marriage, that converted the whole thing and commingled it pursuant to the Fingal case. This appellate court said, well, not exactly. You're entitled to active appreciation, but just because there was commingling here, that does not convert real estate, or at least the separate property. The active enhancement per the statute in CAA, fair game. And that takes us to our fourth case.
Thank you, Eddie. This next case is the Karhoff v. Robata. Excuse me if I mispronounced that. It's a 4th district case. And this one, again, dealt with equitable distribution. This was a 13-year marriage with one minor child who was disabled with medical needs. This trial court essentially had a final judgment on almost every issue possible: equitable distribution, alimony, child support, parenting plan. And when it was appealed, the former wife appealed 6 issues. The former husband appealed another 3 issues. And for purposes of equitable distribution that we're going to talk about, was the trial court allowed the former wife to refinance the marital home, but there was not a provision of what if the refinance doesn't happen, or what if she cannot get a refinance. Now, what the appellate court essentially said is, while the court has authority to award a spouse the marital home and they can offer them time to refinance it, they must provide an alternative if they can't. Otherwise, it's reversible. So in this case, the appellate court reversed, saying that they must relook at this case and afford her the opportunity to refinance. And as the deadline already would have gone up, the court should allow them another opportunity to do that. And in addition, this case is also a great one to read, as they had a plethora of additional issues that, for knowledge, I think would be a great read. And I believe that brings us to the start of injunctions.
Yes, we had 3 injunction cases this month, and I'm going to cover all of them for us. Case number 5 in your materials is Black versus Black, and this is the first of the injunction cases. And this is a case out of the 2nd, and this involved a domestic violence injunction and 2 ex-spouses. And the former husband, who had the injunction against him, he had filed a motion to dissolve this injunction, which had been in place for 2 years. And the former wife, as one can expect, of course, when he filed that, she filed a motion to extend the injunction. And what this case teaches us is that the court had improperly extended the injunction. They denied the former husband's motion to dissolve it, but they extended it. And what was interesting, when the court extended it, there was no new allegations of any domestic violence, no new concerns, no threats of domestic violence, no proof of anything regarding new, recent, imminent fear, danger, harm, anything like that. So the former husband appealed this, and the 2nd district said, correct, you should not have extended the injunction, just because there might be a possibility that these 2 folks will bump into each other out in society, or that there might be future contact between them because of children or whatnot in the future. That's just simply not enough. There needs to be additional new allegations of domestic violence, imminent harm, and all those things that we know about. So that's what the Black case stands for. And then the other injunction case, the next one, is number 6. This is a case, again, out of the 2nd. The 2nd was busy with injunctions in February. They're all from that district. And this is the Maglori versus Obranovic case. And I butchered that. But this involved another domestic violence injunction on behalf of a minor child against mom's former boyfriend. And what this case teaches us is that the mom pled in the petition that she was just fearful, and that there was no additional evidence about any recent events of violence. And what this was a petition, like we see so often in these injunction cases, where everybody sort of dumps out the kitchen sink of all these past harmful or allegations or harmful events, and nothing had happened recent with these folks. So the 2nd district said that granting the injunction for protection of against domestic violence was improper, because there was no recent allegations of anything, and that the mom's fear alone was not enough. And there's a really good discussion about what fear is, and under a reasonable person standard in this case. So it's a good read, but the fear has to be objectionably reasonable, and this whole discussion about that. So that's what the Maglor case talks about and stands for. And the final injunction case this month is Wolf versus Newton. And in this case, there was a stalking injunction, and it was 2 neighbors in a neighborhood, a female and a male neighbor, and the female sought protection against the male neighbor. And the court granted it on an ex parte basis once they read the petition. But when it went to final hearing, the stalking injunction was denied and the petition was dismissed. But what was interesting is when they entered the ex parte injunction, like we see all the time, there's an order that the respondent must turn in all weapons. So respondent complied and turned in all weapons to the Hillsborough County Sheriff's Department. And then, of course, it went to the final injunction hearing and the petition was denied and the case was dismissed. So the male neighbor said, hey, I want my weapons back now. There's no injunction and whatnot. So he actually filed a motion to have his weapons returned. And that's where the whole trial court sort of got on the wrong track here. And the trial court said he needed to set a hearing and he had to come in and testify. And the guy said, I don't have Zoom. I can't do this. And it was a long list of events that happened in this case. But what the finality of this was is that the second district said that once the court entered the order, the final judgment denying the injunction and dismissing the petition, that was when the court lost jurisdiction to do anything else. So it was improper to make this gentleman come in for a hearing, come in and testify and say why he needed his weapons back, because they had no jurisdiction to continue to enter any of these orders. So if there's no rehearing, no appeal, and all that time passes, then they've lost jurisdiction to do any further work on this case unless it's specifically reserved. So that is the Wolf case, and those are the 3 injunctions this month. I think Gina's up next, and we're going to talk about parenting.
Yes, thanks, Karen. This is the only parenting case for this one. It's the Robbins v. Kearns case out of the 1st District. And this was a paternity action with one minor child who was in preschool at the time. So we're talking about a very, very young child here. The court awarded the mother 60% time sharing and the father 40% time sharing. What the trial court also did is they awarded a prospective change of time sharing and said, okay, once this minor child goes into kindergarten, we're going to have equal time sharing. The mother appealed and the appellate court said, no, you can't do that. The court can only determine what's in the child's best interest at the time and the circumstances of this hearing. So by the court prospectively awarding equal time when this minor child was in kindergarten 2 years later was not appropriate. So that is the only parent, that's what we have for this case. And I think that takes us to procedures now.
Can't wait. Thank you for that summary, Gina. The case number 9, Fortini v. De Palma, deals with a business in receivership. Really long opinion. Don't really have the brain power to go into it. If you're dealing with receiverships, check it out. It's out of the 5th DCA. Case 10, Aponte v. Wood, is an interesting procedural case because it dealt with a default based on noncompliance with discovery. In this case, in response to a motion to compel, the husband filed a response totally in Italian. The court entered an order compelling. The husband responded yet again in Italian. And ultimately, the trial court entered a default as a discovery violation. That default was reversed because there was no express written finding of fact supporting the conclusion that the failure to obey the court order demonstrated willful or deliberate disregard. So if you're seeking a default for a discovery violation, the standard's pretty high. Case number 11, Vincent v. Vincent, deals with a writ of certiorari and has a very lengthy discussion about psychotherapist patient privilege. Case number 12, also a writ of certiorari. In this case, it was the writ was denied and it sought with discovery. And in this case, there was a discovery order that was granted. The case really went in to talk about irreparable harm, and writs of certioraries are really appropriate when discovery is compelled, because if discovery is denied, that's something that can always be fixed on appeal. So it doesn't really meet that level of irreparable harm. That brings us to the Singer v. Singer case.
This is a case out of the 4th District, and this is a post-judgment matter. Former wife filed a motion to enforce terms of a marital agreement with the former husband and the former husband's brother. The trial court granted the motion to dismiss. The former wife filed an appeal. And what the appellate court said here is that the trial court erred in saying that they did not have jurisdiction to hear this motion to enforce the agreement because the former husband's brother, Mr. Singer, voluntarily signed this agreement, which then waived his right in saying, you don't have personal jurisdiction over me. So what the court has to do now is basically add in Mr. Singer as a party in order for the former wife to proceed on her motion to enforce. This is a simple case where the brother was the third party to the action. And that takes us to the next case. CARYN?
So the next case, we're still under procedure, is number 14. This is the Karkoff versus Robilata case out of the 4th District down here by us. And this was a case, the opinion is many pages long, but it was an appeal basically of a multitude of issues on the final judgment. But really the most important one that came out of this case is that the court had made some oral pronouncements at the conclusion of the trial. It was a dissolution of marriage action, and court made some oral pronouncements. And then when the written final judgment came out, there was some conflictual details between the written final judgment and the oral pronouncement she made at the conclusion of the hearing. Interestingly enough, this case had a unique situation, and these folks that were getting divorced had one child who had some disabilities, and they had an adaptive van to transport the child. And what happened is, at the time of the final the final judgment came out, there was conflicting language in the parenting plan and the final judgment. The final judgment awarded the adaptive van to the former wife and awarded the husband the Honda vehicle that they had, and then said that each party waives all of their interest in the other vehicle and, you know, normal language like that. But then the parenting plan provided that on the days the dad had time sharing with this child, the mother was supposed to provide the adaptive van for the child so that the father could transport him and timeshare with him, and they were essentially swapping vehicles on those Saturdays or weekends when the dad had time sharing. So very concerning language. So on appeal, all these issues, there was on appeal, there were issues about refinancing marital home, makeup time sharing, parenting coordinator issues, life insurance, a multitude of issues. But what came out of it is that at the conclusion of the hearing, at the trial, the judge had said that each party was going to get their own vehicle. So therefore, it went back to looking at what her oral pronouncements were on the record, and they said that the final judgment tracked the language and it was proper. And that by distributing the vehicles and then saying they each had to exchange it just for the time sharing was not a conflict. So because they were just exchanging on loan, the vehicles were still being distributed accordingly. It was very interesting, different kind of fact pattern on that case. But the sum total of it is that when there's an oral pronouncement and a written judgment and there's a conflict, the oral pronouncements prevail. Okay. The next case still under procedure is the Velez versus La Fontaine case. Very short opinion. This was a writ of prohibition up to the 5th District to disqualify a judge. And basically all it says is that if an adverse or an unfavorable legal ruling without any other evidence is not enough to disqualify a judge. Okay. And then number 16 in our materials is Delgado versus Miller. This is a 3rd District case still under procedure. And this involved a magistrate issuing a report that was then adopted by order of the judge. And it included a whole bunch of restrictions about each party being able to speak about the other party on social media specifically. So clearly these folks had some serious issues if this made it all the way to the final judgment. There was language talking about that neither party can disclose or reveal to any third party the details of financial information from the case. neither party could contact existing or past or future clients of the employers of that person or the other person, and that neither party can engage in social media of any nature that comments directly or indirectly about the other one's emotional, personal life, mental health. And what this was is it was essentially a gag order on these folks that they weren't going to talk about each other out in the public forum, especially on social media. But the problem was that it went too far, and it was restraining future speech, and it wasn't narrowly tailored to just be the litigation issues. So when this did go up on appeal, the appellate court said it was an unconstitutional prior restraint of speech. We have certain rights, and because it wasn't narrowly tailored enough, it just was too broad. So it was reversed. So be careful when you're writing, proposed final judgments and including language that might be specific in a case like that. You can have gag orders in a case if it's that crazy and unique and contentious, but it has to be narrowly tailored. And then the next case still under procedure is another case out of the second, and it's Ludvigsen versus Ludvigsen. And this case involved a request for a psychological evaluation of, I think it was the husband or the father of these children, because mom had concerns about the father's ability to parent and exercise time sharing with their child. And what was interesting as a procedural appellate note is that when there is an issue involving a psychological evaluation, it is an order that is appealable on a writ of certiorari, because once the psychological evaluation would have been issued and conducted, it would create harm that we could not, fix on an appeal later on. So if there's an issue involving a psych evaluation and something being objected to or ordered and things like that, it is something you can take up to the appellate court on a writ. And the problem with this order compelling the psychological examination under 12360 is that it did not contain any specifics as to the testing. It was just this broad-based swipe of an order that said, hey, do an evaluation. It had no length. It had no type of testing to be performed. It had no instructions to the examiner, and it was just way too broad. So the appellate court did take the issue up on appeal in the middle of the case, and it was reversed and remanded back down, and they instructed the lower court that there needed to be the proper provisions under 12360. So we knew exactly what we were doing, and it wasn't just a carte blanche evaluation to the endless degree on this parent. And I think we have one more under procedure.
The last procedure case is Fine v. Fine, case number 18 out of the 4th DCA. And at the trial, the parties have made certain stipulations about life insurance and other expenses related to the minor children. The circuit court judge did not include those stipulations in the final judgment. On appeal, the former wife brought these up, these omissions of the stipulations from the final judgment. And the fourth found that because the wife did not seek a rehearing, she waived those issues and did not preserve them for appeal. Where an error by the court appears for the first time on the face of a final order, a party must alert the court of the error via a motion for rehearing or some other appropriate motion in order to preserve it for appeal. That takes us to support.
The first of the two support cases is Lockwood v. Lockwood. It's a 2nd district case, and this case teaches us when a court can modify retroactive child support that was temporarily ordered. This is a divorce case. During the divorce, there was a temporary support order that was granted. However, in the final judgment, they awarded and recalculated retroactive child support prior to the petition being filed. The appellate court said, no, you cannot do that. You can only, in this situation, they could not look further than the date that the initial petition was filed. This case under the statute, says we were allowed to modify. They could have modified from the date of the temporary support order, from the date of the initial filing of the petition, dissolution of marriage or an initial petition for support, paternity, or supplemental modification. So that's something to consider when arguing about whether retroactive child support should be modified and when it should. That takes us to the final case, Robbins v. CARYN of support.
And what a case it is. Robbins v. CARYN deals with dad who not only had a child in the proceeding, but had 2 children from 2 previous relationships. In the court went and made a determination as to how much child support he would be paying if he had to pay child support for those 2 older children. And the courts refer to this as the speed credit or the speed deduction, referring to a earlier case from 1999. However, in this case, the father was not actually paying child support for those 2 other children. And speed in the Robbins case teaches us that in order to deduct that from a parent's income, it's actually got to be spent per court order. So that matter was reversed in case 20. In your materials, we have all of the December 2020 disciplinary actions, and there was 26 of them. We will talk about them in a future episode. And now we have a board certification tip from Christie Guerrero.
Stephen Squibs presents this month's board certification tip.
Ladies and gentlemen, for the February 15th, 2021 monthly family law case law, we have a very special guest, Christie Guerrero from Jacksonville, who is in a law firm, 2-person law firm. Both attorneys there are board certified, and Christie just passed the 2020 board certification exam. So Christie, congratulations on being one of the 4 folks who passed last year's exam. It's great to see you.
Thank you. I appreciate you having me.
And Christie graduated in 2012, so she's a relatively young attorney to pass this test. And what I found really interesting was she's also used to work for DCF as a child protective investigator. So that has to help your practice in all kinds of ways. Welcome to our show, Christie.
Thank you. Thank you.
So the topic is tips on how to pass the board cert exam. And last year we had 4 people pass it, and we're trying to get that number up, that passage rate up, and was wondering, what steps did you do to approach studying for this exam?
So I had the best intentions. I honestly, the application date snuck up on me. So the year that I could have applied to sit, I did not get my application in on time. But what that meant was that I had a full year to study before I could even apply to sit for the following year. So I marked every Friday off on my calendar for the entire day. I'm going to study, and I'm going to set aside plenty of time. That never happened, not even the first time, because, you know, we're family law attorneys and fires happen. And the very last thing that I was able to do that week was to sit down and study when I needed to prep for the hearing for next week. So then it really came down to timing of it. Again, I started in December thinking, okay, I'm gonna buckle down and do it now. I might have gotten a few hours of study time in December. The bulk of what I did happened after the board cert review class. I did put the 100 hours in. I stopped counting at some point, so my best guess is I put in about 100 hours. For me, I studied the same way that I studied for every law school exam, for the bar exam. I read the outlines. I mean, I read the red books cover to cover. I then went back and outlined them, and then I went over my outlines again and again and again. I was never really an acronym person, but that was the only way I could find to get myself memorizing all of the statutes and all the factors. And so I did that. And yeah, I mean, for me, I think the best thing that I did for myself is the week before the exam, I rented a house in Tampa, and I took myself there and did nothing but study for this exam for that week. You know, it's, you have a busy practice. I've got a family at home. There was no way to do it for me other than to completely remove myself from all of it and just devote that time to studying. And I found that to be really, really helpful. And if I had it to do again, thankfully I don't, I would definitely do that again.
Now, there's a lot of criticism that the test is just too hard, and they give you all the core areas and the subcore areas, so you know what's going to be tested. Did you think the test was a fair representation of what they told you was going to be on it?
I do. I don't think there was anything on the test that wasn't either in the red books or identified on the outline that they gave us. So when I was putting together my study materials, I used that core and subcore list. I checked everything off as I was creating my outlines to make sure that I had covered every subject matter that they told me that they were going to test me on. And I knew everything that I needed to know. The test is difficult, but it should be. And clearly it can be passed, but you've got to put in the work and know the material in order to do it. You can't walk into the test, and I know people that did. I spoke to several people that took the test that hadn't studied at all. They just assumed that if they had put in the 5 years or the 6 years or the 7 years, that their experience would be enough to get them through. I can assure you that it's not. The way this material is tested is not your general practice knowledge. They're not going to ask you what's the standard to modify child support. They are testing the nuances and the very unusual fact patterns, and it's the application of the law, not do you know the standard.
And they give you true, false, multiple choice, and essays. What did you think was the most difficult?
I think they were all equally difficult. The essays, of course, are extensive, but they're complicated. There were some that were easier than others. The ethics is pretty straightforward, but the substance of one, I mean, one of ours was an equitable distribution fact pattern that was complicated, and the multiple choice is difficult because you always, and to some extent, psych yourself out. And well, this could be true. We do what we do. We argue in our own heads. Well, this could be true if this, and this could be true if that. So it's kind of walking yourself back and answering the question that is in front of you without over analyzing it, which I think is difficult for all of us.
Did you, in between your break, did you happen to talk to anyone and get psyched out at the test, or how did that go?
So it's really interesting. Yes, I mean, people didn't come back for the second half of the test. I think those were the people that also had not put any time to study, who thought that they could just show up and take the test and pass it. They didn't realize how difficult it was actually going to be. But for me, the first part of the test was the multiple choice, and I felt really good about it. But yeah, it's hard. It's no different than the bar exam. Everybody walks out feeling as though they just bombed it. There's no way I passed that exam. But you know, don't talk to anybody. If you know it, you'll know it, and you'll be fine.
And I think this year they're doing it remotely based on the pandemic issues, and you will have a proctor watching you as you take the exam to make sure you're not looking at anything. So I think they're doing it kind of like the bar exam. When you took the test, did you type your answer or did you write it old-fashioned way?
I took a laptop and I typed. I can't imagine having enough time to have gotten through all of the essays had I handwritten them. At least not have gotten as much information that I would have wanted to. But I'm faster typer than I am handwriting. Several people did handwrite the exam. I would not. I would highly recommend taking a laptop in. It's not cumbersome. You are able to bring a laptop bag in with you. Well, it's at home now, so remotely. But yeah, I would not handwrite.
And were you able to get all your package in before the test, where you knew you would be, if you sat for the test, you knew you had already passed peer review and all of the requirements, or were you a little late in your application?
So because I had missed the application deadline the year before, I knew this go round what it was going to take to get that application in and done. So I started that process early, and I got it in on time. I did have to supplement my application with some extra information, but that was an easy process. I only had to do that once, and so by the time I sat, I was not concerned about my application at all. I knew that was going to be just fine.
A lot of people, I think, don't appreciate it, that it's very similar to applying for the bar, and it does take a lot of time for the board cert committee to process all of that. And as a past committee member and chair, it's amazing really how much weight they put into peer review and how seriously they take that. So if you are past that process, I think, that says a lot about you as an attorney, that you're even allowed to sit for the exam.
Absolutely.
So all the folks that are out there nervous like you were before you took the test, do you have any tips that might give them comfort or some additional direction?
There's no magic trick. There's no secret. None of us that pass know anything that the people sitting in front of their exam materials don't. If you have practiced well in your career, if you've been a good, thorough lawyer, if you have done your research and been prepared for every hearing you've ever walked into, then studying for this exam you're going to be okay. Yes, you're going to learn new things. I learned new things. I walked out of the test after the experience was over and thought, even if I don't pass this exam, I'm a better lawyer for having studied for and taken this test. So I've come out better, regardless of the exam result. So it's a feat, and the test is difficult, but if you put in the time and do the work, it is a manageable mountain to climb.
And when did your partner, Molly, become board certified?
She passed the exam the year before that I took it.
So you guys have a little niche going on, a nice little boutique firm in Jacksonville.
Yes. We're sad that we cannot market our firm as a board certified firm, but we do, put a little check out there that yes, both of the partners of the firm, we do have some other attorneys here that are not yet board certified, but they will be on their way shortly.
Well, Christie, we appreciate your time today, and thank you for sharing some tips with our viewers. And
Absolutely.
We wish you the best of luck in your career, and we're very proud that you passed this test. So congratulations.
Good luck, everybody.
Thank you, Christie.
Welcome to Stephen's Sandbox, a segment where a Florida family law legend steps into the sandbox with Eddie or CARYN Stevens to discuss ethics, professionalism, their career, and staying sane in such a high conflict industry. Are you ready? It's time to step into Stephen's Sandbox.
So we're here on our next installment of Family Law Legends, and we have with us here today the one, the only Joel Weissman. And Mr. Weissman and I are going to chat about some of the wonderful things of family law, how Joel wound up being where Joel is today, and all those sorts of fun facts and stories. So good afternoon, Joel. It's nice to see you.
Good afternoon, CARYN.
Thank you so much for doing this and spending time with me. I'm very excited to chat with you. So I wanted to kind of dive deep here and ask you, how did Joel Weissman, who was Joel Weissman before family law Joel Weissman?
Joel Weissman, in advance of family law, was a prosecutor for the 15th Judicial Circuit. He was the chief of the Career Criminal Division, left the office in late 1979, opened practice over on One Clear Lake. And in the same building at the time that I opened practice was another young fledgling lawyer by the name of Barry Christie, who became our state attorney. And Barry had a minor matrimonial case that he referred to me based upon some contract dispute. And that contract dispute turned into a national frenzy based upon the wife accusing my client of being responsible for his former wife's murder. And that case was known as Sullivan, and it is still somewhat infamous today.
So that lovely experience got you sucked into this world of family law, huh?
And that led me into the family law arena, in which I embraced it. It had every aspect you could imagine. Criminal law, tax, contracts, and it also had some family law involved with it.
Every once in a while, right? So when you were starting out back, we won't talk about the years, even though you already mentioned it, but back when Joel started. So did you have any mentors, any people you looked up to, maybe even people that didn't know that they were mentoring you in their experiences?
There was a lawyer who I would communicate with from time to time. His name was Tobias Simon. As probably the bar knows now, each year someone is awarded the Tobias Simon Award who donates and allows themselves to assist the underprivileged. And Mr. Simon was my mentor for many years. I would contact him and he would advise me on how to proceed both professionally and responsibly.
Awesome. And anything, if you look back in your experience of practicing in this field, any story that stuck out in your mind about maybe something that was hard and you learned your lesson the hard way, or you got schooled on something at one point? I know that's hard to imagine, but
well,
something.
I'm not sure it's my lesson as opposed to the lesson.
Fair enough.
When we commence the practice of law, we commence it with our eyes wide open and we have great expectations. We develop a reputation almost immediately, and that reputation follows us forever. The one aspect that I've always honored was not to castigate my fellow lawyer, because it may come back to be detrimental in some form. And the perfect example that I can provide you is that when I was young and enthusiastic, there was a lawyer on the other side of me that constantly berated, whether it was the opposing party, the opposing counsel, or even a witness. And as it turned out, this person who was causing such pejorative problems for people berated the wrong individual, who ultimately became a circuit judge. And during a controversial fee hearing in which I participated with this other lawyer, the judge made a decision and the lawyer objected, saying that it was the wrong decision. And the judge used the following words to this particular lawyer. In essence, do you remember berating me and calling me ignorant? So you cannot expect me to make a ruling because I'm an ignorant person still in your favor. And that came back to be resonating to me all of the time, that what you say to someone may be harmful or helpful, but you need to really be careful of the words, because you never know who you're going to meet later on in your career.
I think that's an excellent point, because the community out there, the more you do it, and when you're in it for a number of years, you realize how small it is. So I completely understand what you're saying there. So in your time and practice, do you have any fun stories, anything memorable that sticks out that you're still sitting here chuckling in your head or laughing to yourself about years later?
Well, there's so many. But the issues that I remember the best are different than the issues today. Because years ago, we had only fax machines. And so we only communicated by fax. And one of the ways to stop communicating, which is unlike today, was we just shut the fax machine off. So you never had to worry about communicating. But in this modern era today, with the emails and the texts, that's not a possibility. And that's one difference in the practice of law. The other difference that comes to my mind is the camaraderie that we used to have. Hopefully it's coming back, but it deteriorated in the last 10 or 15 years. Now, the family bar is a little different, but in the general bar, there was only 300 lawyers here in Palm Beach County in the early practice, and we knew everyone. And so we didn't have the same difficulties as we do today, because today we're almost anonymous, and you do not even meet the person, you just email the person. So those are the kinds of practices that are different and amuse me, because when you pick up a telephone, somebody's so surprised to hear your voice and to understand that you really are someone, not a robot.
Absolutely. Absolutely. Thinking about where you are today, you're a board certified matrimonial attorney here in Florida. And if there was someone sitting out there listening to this interview thinking about, should I sit for a board certification exam? Is that something that's beneficial to my career? What sort of advice would you give them, and what would you recommend?
Every moment that you could be more intense in the field, you should embrace. If you could be board certified, you should embrace it, because people today are a little more sophisticated, and they want lawyers who they understand are following the current trend of the practice and who their peers believe are exceptional being board certified. And they're not looking for the average individual. They're looking for the better than average individual. So I believe that board certification is an extremely important tool to have as a matrimonial lawyer, or any lawyer for that matter.
Okay. So what about any tips, any recommendations about sitting for the examination, going back?
Well, obviously, you shouldn't be the enemy of your opposing counsel. You don't need that. You also have to make sure that you get paid. See, that's the issue. As a practicing lawyer, one of the foremost things that need to be done is to be paid. And so you need to be honest with your client. You should have a fee contract that addresses how you're supposed to be paid and why. And as a lawyer today, because there's so many of us, you do not take for granted that client's ability to always be there for you. There's really not as much loyalty as there was. So that client is important, but it is not the end all. And so the lawyer should remember to be independent of the client and respect the client, but the client is a person who is there for services and should be paying for your services. And once you pass that proposition that, well, they're my friend, that's when you're going to see yourself in deep trouble regarding your collection of fees and costs.
Okay. And thinking about this field that we practice in, and what you just said a few minutes ago, that seems like we're always accessible. Text, email, maybe not so much phone anymore, but the text and the emails and the 24/7. So how do you sort of deprogram and go home or leave something at the office? What works for you to sort of relax after we do this wonderful practice all day long?
Well, I'm in an unfortunate category that I do not have as many clients as others who are required to have a substantial cash flow. So I'm going to talk to you from 45 years of experience. Second level is I'm always accessible if you want to literally pay for that accessibility more so on a weekend than you would on a weekday. So that curtails many people from contacting one if they're going to pay an additional fee for that privilege. But the third level is that there really needs to be some decompression. and I try as best as I may shut down on the emails, the texts, understanding that they'll be there and that the client knows that I will be responding, but not instantaneous. As I tell my clients, I am not a microwavable lawyer that you just put in and turn on. It will take some time, but it will eventually, it'll be responded to. And if there's a real emergency, then 911 is the only answer, because Joel Weissman doesn't handle emergencies well on weekends.
I like that, the microwavable layer. That's good. I mean, are these discussions that you recommend people, you know, from your experience, that people have in the initial consultation? You think that's something that's important from the get-go?
Say that again, CARYN?
I said, do you think that these sort of boundaries, limitations, these sorts of, you know, how you're accessible or not, is that something that you think should happen in the initial consultation when someone's meeting with an attorney, or how do you handle it after all these years?
Well, there's two levels, as you know, in the matrimonial field. There's the children issues, and then there's the financial issues. And so regarding the children issues, boundaries and filters are not necessarily adhered to. People are distraught because something happened with their child, which is understandable, and they need a response. And I try to be as responsive to that as possible. The financial issues is a different level. I try to explain to the clients that the financial issues will be a little bit more tardy, but they'll ultimately be resolved. And unless someone is literally removing the house from the foundation, I don't expect them to contact me in an emergency over whether or not someone's spending some extra dollars that they shouldn't be, or not paying an invoice that should have been paid on a Saturday as opposed to a Monday.
Okay. And we've had an exceptionally bizarre past year, especially in this kind of practice. So you're looking back at 2020 now. How do you think we've done as a group, as a profession of just lawyers or matrimonial attorneys? How do you think we've done transitioning into this sort of new electronic world?
It has been tedious, but it has also been very fruitful. Tedious to the extent that where we were comfortable in attending a hearing and providing the information to the court almost at the time of the hearing, today we do not have that luxury, and it becomes a situation that needs to be accomplished in advance. So the tediousness of obtaining the filing information and obtaining the writing, providing it to the court, opposing counsel, or wherever else, that's more than what was accomplished for the last, my practice, at least 44 and a half years. This year has some benefits. We do not have to travel to various courthouses. We can practice law just as we are now, as speaking to each other. And it just requires us to have the capabilities of understanding that 3-dimension, as we are used to, may not be the programs that we're going to be accomplishing in the next year or two. It's going to be less. It has benefited us by not going to motion calendar and non-evidentiary hearings. It has been more difficult because you cannot place into words a moment at a deposition where you know that that person is being untruthful and you've discovered that and captured that, as opposed to having them be untruthful with a cup of coffee in their hands and relaxing with a Tommy Bahama shirt. Totally different atmosphere. Same result, but a little different third dimension.
Absolutely. Absolutely. And you've had some really wonderful, fabulous accomplishments in your career. I mean, you've set the law in some areas of law. You know, we're talking about prenups and Hahamovich, and looking back at sort of this, I hate to use the word legacy, but this legacy of the law that you've created. I mean, what are you most proud of?
Most of it being fortuitous, some of it being insightful. But let's talk of fortuitous. First, you have to have the client that has the capabilities of allowing you to go to the next level, meaning the appellate level. You also have to be fortuitous in the sense that you have the correct facts. So if you have the finances and the facts, and you have the client that's interested, you can make some substantial law. And I'll give you some of the cases that was never thought about, but turned out to be cases in which all of us use daily. So there's the Satter v. Satter case on legal fees. There's the Ashero case used on children issues. There is the Levine versus Levine case used for alimony. There is a Hamovich case that you discussed. But those cases, as substantial as they were, and as substantial as they are, they were cases in which the clients had the capabilities and desire to create substantive law for others. The case that I found to be most interesting and certainly ordinary was I represented a young lady whose husband was the founder of some very substantial mutual fund. And the prenuptial agreement was rather simplistic. If either one of them committed adultery, then something good would happen or something bad would happen. And in her case, she was going to receive substantial sums every month if he committed adultery. She finds in her home in the state of Vermont a bed sheet, a nightgown, and some hair samples. And I have them laboratory tested for DNA, and I have her DNA. And sure enough, it's not hers, it's a female and a male. So in our practice, we know that we have a request to produce, and I went into court on a very simple request to have DNA samples from the husband. And some reporter was in the courtroom at the time and wrote a one-page line. Wife's lawyer requests DNA to prove adultery. Unbeknownst to me, that one-page line became the headline throughout the world. I seem to be the first lawyer that ever requested that. And because of that, I went on the Oprah Winfrey Show. And here it was, for no purpose other than to assist my client as we ordinarily would do. And so that moment in time, with the other cases and the fortune that I've had, compelled my name around a little bit more, and now gave me national attention and international attention over one simple motion. Can I have a DNA sample so I can prove that you've been salacious in your life?
All the accomplishments, and it was the bed sheet and the DNA that got you on Oprah, right? There
you go. All of the things that we could have done. Look at what here, look at this, and look at that. Wonderful. But this is what we need. We need titillating information. We need something scandalous. We don't need what the law may provide and how it can help countless others. But we want to know about the scandal of the sheet and the nightgown and the hair sample.
See, everybody always thinks family law is sexy, and it's only sexy like 1% of the time, right, Joel? Like
maybe 1% of the time.
The other 99 when you're going through bank statements, not
no,
so
you have to tell your readers that, you and I were adversaries, and we made every moment possible as aggravating as we could to each other. But at the end of the day, we knew that we were representing clients. We weren't representing each other. Absolutely. And that we always were professional and continue to be so.
And I'm sitting here interviewing you now and thinking of you as one of the legends in the field later, because you are that true gentleman. So I appreciate that.
Well, and that's the point. If we could express any moment why matrimonial lawyers ought to be kind to each other, it is because the clients will always be there and they may want us to be combative, but that's the courtroom, not outside the courtroom. And we never know when we're going to need each other for whatever purpose. And if we don't have each other, then we really have nothing in this practice of law.
I couldn't agree more. I couldn't agree more. So I really appreciate you chatting with me, Joel, and letting me interview you for this little segment of legends in the field. And I truly, truly believe that you are one of them and continue to be one of them.
Thank
So
you,
thank
CARYN.
you. And I appreciate all of the hard work that you've done for us younger lawyers out there, you know, burning the midnight oil and trying to get this done. So thank you for that.
We still have much more. We have much to go.
Thank you for joining us for this month's edition of Stephen Squibs' Monthly Family Law CLE. We hope to see you again next month. In the meantime, do something that matters. Visit www.eddiestevens.com for more information.